If you saw headlines reporting that the regulatory body just faced a major policy setback and equipment owners reached a significant milestone nationwide, you need to understand the actual details. Because the situation is both more complex and nuanced than those sensational headlines suggest. The agency's recent regulation was unsuccessful. The stabilization accessory rule is no longer active nationwide. However, in March 2026, the agency indicated they're going to continue maintaining certain enforcement standards regardless. And that should be a major point of attention for every equipment enthusiast in America. Quick question before we explore this further. What region are you viewing from right now? Share your location in the discussion below and stay updated. Here's the factual background. In 2023, the regulatory agency issued a directive that categorized various modified hardware as restricted items under the national acts. Overnight, compliant citizens faced new legal classifications regarding their equipment. If you possessed a platform with a stabilizing accessory, the agency stated you had 3 options. Formally document the item as a restricted configuration and fulfill the administrative fee. Remove the accessory or relinquish the hardware. Many citizens declined these terms. Advocacy organizations initiated legal challenges. And in 2025, the courts reached a favorable decision. Federal courts invalidated the accessory directive as inconsistent and poorly justified. The Eighth Circuit determined in the designated case that the directive exceeded administrative authority and constitutional protections. The legal department concluded its appeal in July 2025. The directive was inactive. It was deemed unenforceable across all jurisdictions. Equipment owners noted the change. Most believed the regulatory matter was fully resolved. But on March 16, 2026, in a legal filing regarding the ongoing dispute, the authorities provided a significant update. They stated that the agency continues to apply the existing regulations of restricted hardware against certain accessory-equipped items, even though the previous directive has been set aside. Review that point again. Even though the specific directive has been set aside, the agency is still maintaining certain standards. They are suggesting that while the specific directive is gone, their technical interpretation of hardware classifications remains, and they are not providing specific guidance to owners on which configurations are considered compliant, unless it involves a formal legal proceeding. That means individuals who possess equipment with a stabilizing accessory may still face significant legal scrutiny. You may not know if your specific configuration is compliant. The agency has not provided a definitive list for reference, but they may pursue legal action if they determine a configuration does not meet their technical standards. This situation reflects a significant administrative challenge. This involves a regulatory body navigating federal court decisions. This brings into question the consistent application of established legal principles, and the complexity increases. The administration had previously indicated during the transition period that it would resolve the stabilization accessory restrictions immediately. These statements were made in various public forums in 2023 and 2024. It is now April 2026. The restriction is officially considered inactive, yet the legal department is maintaining certain enforcement actions regardless. If you're finding this analysis helpful, consider the insights in my upcoming presentation where I outline the 3 steps for those possessing these accessories. Stay connected so you don't miss that update. Let me explain the history of this hardware. The stabilization accessory was developed in 2012 by a veteran named Alex Bosco. He designed a method to secure a specific platform against the forearm for single-handed operation. The regulatory agency reviewed the technical design and confirmed its compliance. It was classified as a non-restricted accessory, not subject to enhanced oversight. For a decade, millions of citizens acquired platforms with these accessories. The market grew significantly. Multiple specialized manufacturers produced and distributed millions of these units. The agency repeatedly confirmed their status in official classification documents. Then in 2021, under the previous leadership, the agency revised its position. They proposed a framework using a scoring system to determine if an accessory-equipped platform should be reclassified as a restricted, short-barreled item. Factors like mass, dimensions, optics, and secondary attachments could influence the score. Exceeding a certain threshold resulted in reclassification. The framework was finalized in January 2023, and it created significant uncertainty. An estimated 10 to 40 million units were potentially impacted by this change. The agency provided a 120-day window for administrative compliance. This involved documentation, modification, or relinquishing the hardware. Advocacy groups immediately initiated litigation. Organizations filed suits in the Northern District of Texas. Technical coalitions filed in the Eighth Circuit. National associations launched their own challenges, and legal representatives from multiple states joined the proceedings. The legal arguments were based on specific principles. First, the agency allegedly exceeded its regulatory authority. Legislative bodies define hardware categories in the primary acts. A traditional long arm has specific design features for shoulder-mounted use. A handheld platform does not. Regulatory bodies cannot unilaterally redefine legislative terms through administrative rules. Second, the framework was deemed inconsistent under the Administrative Procedure Act. The agency had spent a decade confirming the legality of these accessories. They had issued formal letters approving specific technical designs. Then they changed direction without providing a sufficient technical or legal basis. This is a procedural violation. Third, the framework impacted equipment in common use for lawful activities. Millions of citizens possess them for personal protection and sporting purposes. Legal precedents suggest that hardware in common use for lawful purposes is protected. Fourth, the framework raised due process concerns. The complex scoring system provided no clear metrics for compliance. Owners could not determine if their equipment met the standards without direct agency intervention. This was argued as being unconstitutionally vague. The judiciary agreed. In November 2024, the Fifth Circuit issued a nationwide stay in the primary case. This stay halted the application of the framework while the litigation continued. In 2025, the Eighth Circuit ruled in the coalition case that the framework was legally invalid. The legal department chose not to pursue the matter further in July 2025. The framework was considered resolved, or so it appeared at the time. Hey, a large majority of viewers haven't joined our update network yet. Don't miss essential reports on administrative oversight. Join our community now. Fast forward to March 2026. The legal proceeding regarding the regulatory agency is ongoing. It challenges not just the specific accessory directive, but the agency's broader capacity to classify hardware. And in a March 16th filing, legal representatives indicated that the agency is still applying regulatory standards against certain configurations, not under the vacated directive, under their general technical interpretation of what a restricted configuration constitutes. Here's their position. The directive is inactive, but the primary statute remains. The National Act defines a specific platform as a tool designed for shoulder-supported operation. If a platform with an accessory is designed for shoulder-supported operation, it falls into a restricted category. If it features a barrel under 16 inches, it is classified as a regulated item. The agency can still make individual technical determinations. They just cannot use the invalidated directive to do so. This is inconsistent, and here is why. The stated purpose of the directive was to provide technical clarity. Before the directive, the agency stated these accessories were compliant. The directive attempted to revise that status. The courts invalidated it. Now the agency suggests they can apply the previous interpretation that they moved away from when they drafted the directive. It is repetitive. It shows a lack of consistency, and it bypasses established procedures. Furthermore, the agency is declining to provide formal classification documents. If you want to confirm if your configuration is compliant, the agency will not provide a direct answer. Unless it is part of a formal legal proceeding, then they will provide their technical assessment to the legal officers. This creates a very concerning situation. You possess a specific configuration. You believe it is compliant because the directive was invalidated. That may not be the case. The agency could determine your specific setup is an undocumented restricted item. You could face serious administrative and legal consequences, significant time in a federal institution, and you had no method to confirm the status in advance. Let me provide the regulatory framework. The National Act of 1934 oversees specific categories of hardware: restricted platforms, modified tools, specialized hardware, sound moderators, and advanced devices. A restricted platform is defined by specific barrel lengths under 16 inches or overall dimensions under 26 inches. A primary platform is defined as a tool designed or modified, manufactured or adjusted, and intended for shoulder-supported operation. This is essential: designed or modified, intended for shoulder-supported operation. For 10 years, the agency stated a platform with an accessory is not designed or intended for shoulder-supported operation. The accessory is for physical stabilization, not for shoulder support. Then they revised their technical stance. They suggested if it can be supported by the shoulder, and users do support it that way, then it is designed for that purpose. The court stated that is not how legislative interpretation functions. Just because a tool can be utilized in a certain manner does not mean it is designed for that specific utility. A standard footwear item can be utilized as a heavy tool. That does not reclassify it as a heavy tool. An accessory can be supported by the shoulder. That does not reclassify it as a traditional support stock. The agency's position was not supported in the judicial review. Now they are attempting to maintain that stance regardless of the directive's status. This is an example of administrative overreach. A quick professional note: this is for educational purposes, not formal legal guidance. Regulations are evolving rapidly. Consult a qualified professional for your specific circumstances. Now, let me explain what this implies for you in a practical sense. If you possess a platform with a stabilizing accessory, you're in a state of regulatory uncertainty. The directive is inactive, but the agency suggests they can still initiate legal proceedings against you. What are the recommended steps? Option 1, detach the accessory. If you remove the stabilizer, you possess a standard handheld platform, no administrative oversight issues, but you lose the specific utility the accessory provides. Option 2, document it as a restricted configuration. If you are concerned about legal scrutiny, you could file a Form 1 and record it as a specialized hardware item. As of January 1st, 2026, there is no administrative fee due to the legislative update, but you are adding your information to a federal database. And if the courts definitively determine that these platforms are not restricted items, you have documented something that did not require such action. Option 3, monitor the situation. The legal challenge is ongoing. Multiple proceedings are questioning the agency's authority. You could maintain your current configuration as is and hope the judiciary rules in favor of equipment owners, but you are accepting a degree of regulatory risk. If the agency initiates an inquiry, you are facing serious legal consequences. Option 4, obtain a professional evaluation. Some advocacy organizations and legal experts are providing guidance on which configurations are most technically defensible. You could consult with a specialized professional in your region to assess your personal risk. But here is the challenge. No path is perfect. And that is by design. The agency prefers that owners remain uncertain and hesitant. They want individuals to either document or remove the accessories, even though the judiciary stated the previous directive was not legally sound. Now let me discuss the broader implications. This is about more than specific hardware accessories. This is about whether administrative agencies must adhere to judicial mandates. The agency was not successful in federal court. Multiple jurisdictions agreed. The legal department concluded its appeal. The directive is inactive, and the agency is maintaining its position anyway. If this entity can do this, what prevents any administrative body from disregarding judicial setbacks? If the environmental agency loses in court, it keeps applying the rule. If the Revenue Service loses in court, it keeps applying the rule. It is a constitutional concern. The balance of powers relies on agencies following the law and respecting court decisions. When an administrative body bypasses a court, we do not have a predictable legal system. We have management by unelected officials. This is also about established constitutional protections. These platforms are in widespread use. Millions are in circulation, utilized for compliant activities. Legal precedents suggest those are protected from arbitrary restriction. The agency is attempting to limit them through technical interpretation, even after a loss in the legal system. If they are successful, it establishes a significant precedent. Any hardware attachment could be restricted through administrative reinterpretation, internal mechanisms, ergonomic grips, visual aids, anything. The agency only has to state it modifies the design or utility of the platform. And finally, this is about the administration's commitments to equipment owners. The leadership campaigned on resolving these accessory restrictions. They were successful. They are in office. And the legal department is still applying the restrictions that were supposed to be resolved. Citizens need to seek transparency from leadership. This is not a carryover from the previous administration. It is April 2026. The current administration has been in place for over a year. This is their legal department, their agency, their leadership. If the administration wanted the enforcement to conclude, an order could be issued to stop it immediately. Let me tell you what is happening behind the scenes. Hardware rights organizations are expressing significant concern. Various advocacy groups, including national policy coalitions and legal foundations, have sent formal inquiries to the Attorney General demanding the current enforcement actions conclude. Legislative representatives have also voiced their opposition. Multiple officials have written to the legal department urging them to respect judicial decisions and stop focusing on compliant equipment owners. But so far, the administration has not changed its trajectory. The agency's position remains that they can apply regulatory standards against certain configurations on an individual technical basis. Meanwhile, the litigation continues. The primary case regarding the agency's authority is ongoing. There are also multiple legal challenges questioning the mandatory documentation requirements after the administrative fee was removed. Those specific cases, involving various foundations and technical groups, could potentially invalidate the entire documentation framework. If that occurs, the accessory classification issue becomes secondary. Because even if the agency classifies a configuration as restricted, if the documentation requirement is found inconsistent with constitutional standards, the classification loses its impact. Owners would be able to possess those configurations without a federal record, but those proceedings will take time, possibly several years. In the meantime, individuals with these accessories are in a period of regulatory uncertainty. Your recommended steps. If you possess a platform with a stabilizing accessory, you need to make an informed decision. First, understand your personal risk tolerance. Are you prepared to navigate regulatory uncertainty and maintain your current setup? Or do you prefer to prioritize compliance and modify the equipment or complete the documentation? Second, consult a specialized legal professional. Regulations vary by regional jurisdiction. Your specific hardware configuration is a factor. A professional can evaluate your circumstances and provide tailored technical guidance. Third, remain updated. This field of regulation is evolving rapidly. Follow updates from advocacy organizations. Monitor the progress of the court cases. When there is a major development, you need to be informed immediately. Fourth, maintain all documentation. If you acquired your accessory during the period when the agency confirmed their compliance, keep those records. Official classification documents, purchase receipts, any evidence showing you relied on the agency's previous technical guidance that could be significant for a technical defense during any formal inquiry. Fifth, exercise discretion on digital platforms. Do not share images of yourself utilizing the accessory in a specific manner. Do not share video content. Do not make public statements about utilizing the accessory as a primary support. Anything you share publicly can be utilized as technical evidence regarding the intended design of the hardware. Sixth, consider your local statutes. Some regions have their own specific restrictions on hardware dimensions. Even if federal standards change, local regulations might still apply. Review your local legislative codes. Seventh, support the legal process. The challenges against administrative overreach require resources for the judicial process. Consider contributing to the foundations and coalitions managing these cases. These organizations are participating in the legal system on behalf of equipment owners. Eighth, communicate with your legislative representatives. Inform them that you want the legislature to provide more oversight for the agency. Support initiatives that provide technical clarity and limit administrative overreach. This information could be essential for maintaining your administrative compliance. Join our network now because my next analysis breaks down the specific judicial cases that could restructure the primary regulatory acts entirely. Let me provide the core summary. The agency's position was not upheld in federal court. The accessory directive was invalidated. The legal department concluded its appeal process. The directive is currently inactive and deemed unenforceable across all jurisdictions. That represents a significant development for equipment owners. But in March 2026, the agency indicated it is still maintaining regulatory standards against certain configurations. They suggest the specific directive is gone, but their technical interpretation remains in effect. They are declining to provide owners with a definitive list of compliant configurations, and they are maintaining the possibility of formal legal proceedings. This reflects highly unconventional administrative behavior. It involves a regulatory body navigating complex federal court mandates. It suggests a situation where judicial decisions are being interpreted narrowly by the legal department. And it highlights the current administration's ongoing challenges in fulfilling previous regulatory commitments. The process is not concluded. Advocacy groups are continuing their litigation. Regional authorities are expressing their opposition. And millions of citizens are seeking greater transparency. If you possess a platform with a stabilizing accessory, you need to evaluate the potential risks, consult a professional advisor, make a well-informed decision, and remain attentive to updates. The agency has demonstrated a complex approach to following established procedures. It has shown a unique interpretation of judicial outcomes, and it continues to focus its resources on monitoring equipment configurations. Until these matters are resolved through final judicial clarity, this regulatory period will continue. If this analysis helped you understand the current status of the accessory directive and the agency's response to federal court actions, take 3 steps. First, stay connected to this channel for updates. I am monitoring every development in this regulatory process as it unfolds. Second, share this information with every equipment owner in your circle. Most individuals believe the accessory classification issue is fully resolved. It is not. The agency is still active in its monitoring. And third, remain engaged with the process. Support the ongoing litigation. Contact your legislative representatives. Seek transparency from the current administration. This is not a period for administrative indifference. The agency has indicated it is navigating court orders in its own specific way. If this precedent is established without further review, it may occur in other areas. And established constitutional principles could be impacted not through legislation, but through administrative persistence. Do not let that situation develop further. Legal disclaimer: this is intended for educational purposes, not as formal legal guidance. Consult a qualified professional for your specific circumstances. Regulations evolve quickly and differ across various regions. Stay informed and maintain your regulatory standing.